Hello everybody, and thank you so much for watching. Today I'm going to be talking about a very interesting development in our Constitutional Court. As at date of recording this video, the judgment is a mere 2 days old. The judgment I'm talking about is the Ad Hoc Central Authority for the Republic of South Africa and another versus Koch N.O and another, and the citation is 2023 ZACC 37. Now, this judgment is quite interesting insofar as the Constitutional Court critically evaluated how Hague Convention matters are dealt with. So myself and my colleague Chante Mouton wrote a little piece on the issue. However, understanding that not everybody has time to go read blogs in these busy times, I have decided to do a quick little video recapping what we have to say about the judgment. And our article is called "From Retention to Resolution, South Africa's Constitutional Court Addresses International Child Abduction." So she starts off saying, "As an attorney with a keen interest in expat and international family law, I'm acutely aware of the complexities that arise within family matters cross international borders. One such matter that caught the attention of legal professionals and affected families alike is the recent case deliberated upon by South Africa's highest court, the Constitutional Court, namely the Ad Hoc Central Authority for the Republic of South Africa and another versus Koch N.O and another, and the citation again 2023 ZACC 37. This case, entwined with the intricate fabric of international law, brings to light the challenges and implications of international child abduction under the Hague Convention. In this video, I'll try to guide you through the background facts of the case, dissect the legal principles at play, and outline the court's order. Further, we'll also discuss the significance of the judgment within the ambit of South African law and what it means for similar cases in the future. So let's start with the background facts of the case. The matter at hand involves the Hague Convention, as I mentioned, a treaty that provides a legal framework to ensure the prompt return of children wrongfully removed to or retained in a contracting state. South Africa, as I'm sure you're aware, is a signatory to the Hague Convention, together with a plethora of other states, notably in this case including the United Kingdom. In this matter, a child, referred to herein as E for confidentiality's sake, was taken by their mother from the United Kingdom to South Africa. Initially, the journey was for medical treatment for the mother, but as circumstances evolved, it became a case of retention against the father's will, setting the stage for a continental legal battle. The father, who was in the UK at the time, contested the retention and sought the immediate return of E under the Hague Convention's mechanisms. After initial hearings by the High Court, the case journeyed through the South African legal system over a period of 4 years, eventually reaching the zenith of judicial scrutiny, the Constitutional Court. The Constitutional Court delivered its judgment on 27 November 2023. So let's go into the legal principles and the court's reasoning. So at the core of the dispute was the interpretation of Article 13 sub B of the Hague Convention. Now, Article 13 of the Convention reads as follows: "Notwithstanding the provisions of the preceding article, the judicial or administrative authority of the requested state is not bound to order the return of the child if the person, institution, or other body which opposes its return establishes that A, the person, institution, or other body having the care of the person of the child was not actually exercising the custody rights at the time of removal or retention, or had consented to or subsequently acquiesced in the removal or retention, or B, there is a grave risk that his or her return would expose the child to physical or psychological harm or otherwise place the child in an intolerable situation." This article becomes the fulcrum in cases where it is asserted that returning the child would lead to a grave risk of psychological harm or otherwise place the child in an intolerable situation. The court was tasked with scrutinizing expert opinions, including assessments of E's attachment to their primary caregiver in South Africa, the aunt subsequent to the passing of E's mother, as well as the psychological impact of separation from this attachment figure. The Constitutional Court was divided in its approach, with a narrow majority favouring the return of the child to the UK. 4 justices decided against the return, while 5 justices of the Constitutional Court, including the Chief Justice, favoured the return of the child to the UK. Now, this is interesting and highlights the nuanced considerations of E's best interests, the father's custodial rights, and the support systems available in the UK to ensure the transition would be as smooth as possible. However, what sealed the deal in this case was the positive obligation placed on the South African authorities by the Hague Convention and the imperative that these must be adhered to by the South African courts. So this decision reaffirms the South African court's commitment to the Hague Convention in the wake of several judgments where the courts were very reticent to order the return of children under the Hague Convention. So this brings us to the order of the court. The order, reflective of the intricate deliberations, mandated E's return to the UK at the end of February 2024, giving approximately 3 months lead time to facilitate this process. It catered to the possibility of the aunt accompanying E back to the UK, which would obviously ensure continuity of care and emotional support for E during this difficult time. The judgment made extensive interim provisions to facilitate the execution of its order, and very interestingly, the court made no order as to costs, reasoning that none of the parties conducted themselves in a manner worthy of censure. So what is the significance of this judgment in South African law? So it can be argued that the judgment is a watershed moment in South African law. As mentioned earlier, it reaffirms that our legal system is in fact dedicated to adhering to the Hague Convention after a few shaky judgments where our courts declined to return children to the countries of their former habitual residence. The divided opinion within the court spotlights the ongoing judicial discourse on how best to harmonize international treaty obligations with our own domestic law, and it illustrates that this is never really a clear-cut matter. It is always open to interpretation and dissenting opinions. It's noteworthy to mention at this stage that this judgment does come from the Constitutional Court, so it will henceforth be binding on all courts in South Africa. Finally, one would be remiss in discussing this judgment if one does not touch on some of the statements made by the Constitutional Court regarding the fluxion of time in these types of matters. Now, as you would have no doubt calculated by now, at the time of the application being launched, 2019, the child in question was 2 years old and is now, at the time of the order for their return to the UK, 6 years old, and obviously in a position where for 4 years there has not been any bonding between the child and the father in the UK. This obviously has very severe effects on the child and will have to be managed very carefully going forward. Now, the fluxion of time in this matter is very noteworthy, a period of 4 years that has transpired, and unfortunately this very significantly and profoundly goes against the purpose of the Hague Convention. The Hague Convention is not a mechanism for final adjudication on parental responsibilities and rights. It's supposed to be a quick mechanism for children to be returned under the convention if they were wrongfully removed from a jurisdiction or wrongfully retained in a jurisdiction. After 4 years, one can very, very clearly understand that the damage of the removal had already been done. The silver lining is obviously, at least, that in the final moments of the skirmish, the courts did decide to adhere to the principles of the Hague Convention Nevertheless, a 4-year inflection of time is simply unacceptable when it comes to the purpose of the Hague Convention. The Constitutional Court had quite strong words to say and essentially called upon the high courts to develop more effective and quick mechanisms, and went so far as referring to practice directives that could and should be implemented to do this. In closing, the complexities of international child abduction cases require a delicate balance between legal obligations of the treaty states under the convention and the child's best interests. As we navigate these challenging waters, it's imperative to prioritize swift and sensitive resolutions in Hague matters. One can only hope that the High Courts will take this judgment to heart and develop practice directives and other mechanisms to facilitate the quick, or at least quicker, resolution of these types of matters. For more information, please do visit our website www.vermeulenlaw.co.za or get in touch with myself or Chante via email. Thank you so much for watching. Please do consider subscribing to the Vermeulen Attorneys YouTube channel, the ThinkLegal LinkedIn page, and the Vermeulen Attorneys LinkedIn page, all of which platforms will be hosting this video once it has been edited. Thank you very much, and until next time, I've been Mervyn Vermeulen, Managing Director of Vermeulen Attorneys.